Cool, nice.
No.
Okay, guys, let's get started. So, thank you for coming in on a Saturday. Today will be your review session. What I want to do is spend roughly maybe 15 to 20 minutes just giving you a really broad overview of the doctrine, and then we can transition into questions about specific areas of the doctrine that you guys have questions about. That'll be the process, so we can go as long as 2 if needed. It's going to continue just as long as you guys have questions for today. So I'm glad to answer any questions about, again, the doctrine, the black letter law, and I'm also happy to answer any questions about the exam itself, technical aspects, strategy, anything that you might want to know to maximize your chances of doing well on the exam. Again, the exam is written. It's going to be 3 hours long, 20 multiple choice questions, 2 fact patterns. Is the composition of the exam. Roughly 1/3 of the weight will be assigned to the multiple choice questions. 2/3 will be assigned to the fact patterns. And again, the exam is worth 70% of your final grade, 10% to your midterm, and then 20% to performance with regard to participation. Yep?
Any policy?
Maybe. So I'm not going to disclose that. So be ready to argue any prospective policy questions. We spend a lot of time in class, obviously, discussing policy in connection to doctrine, but also policy as it relates, it's kind of like distinct sort of discussions to doctrine. Okay? Okay, so we obviously started the class examining intentional torts, and what obviously ties intentional torts together is that you need to have a specific the mental state is what distinguishes intentional torts from negligence. There has to be a intentional desire to bring about a specific injury on to the plaintiff. The defendant has to have that intent, and we know that intent requirement is the primary element that cuts across and that unites all intentional torts. We talked about the 2 primary distinctions with regard to the intent requirement. Remember, distinguishing general knowledge from specific intent to bring about a particular kind of harm. And here, the primary distinction between the 2 largely rests on the plaintiff trying to make an argument for specific intent as a strategy to garner or perhaps argue before the court that he or she should have access to punitive damages. That's the primary distinction. We don't need specific intent, we know, to give rise to an intentional tort. General intent is fine enough. But here, again, the strategic distinction is with regard to the sorts of damages and perhaps the scope of damages that might be assigned by the court. We first talked about the range of intentional torts that we classify as intentional torts to persons. We talked about battery, obviously, which has 3 elements. We talked about assault, which we can think about assault as an incomplete battery. Then we finally talked about the 3rd being false imprisonment. We didn't spend time talking, we ran out of time before we talked about intentional infliction of emotional distress, which is its own classification in the textbook, but that will not be tested for our exam. Okay, so 3 intentional torts to persons that we want to be mindful of: battery, assault, and false imprisonment. And obviously, each of these have their own distinct set of elements. You have to know the elements and know that the elements you apply are going to hinge on the specific issue or theory you're bringing. And again, we know that we know from the midterm that if you bring, sometimes the set of facts give rise to the possibility of arguing battery, assault, and or false imprisonment. If you make 2 or 3 arguments resting on intentional torts to persons, each of those receives its own IRAC, right? We're not conflating and integrating one super IRAC for distinct intentional torts claims. And we also know that intentional torts to persons have their own sets of defenses, largely the primary one being consent, right? That the plaintiff is consenting to the physical touching, battery, is consenting to the behavior that might give rise to the assault, or might be consenting to being confined within a space, of either a physical space or a space created by the words, directions, physical menace of the defendant for false imprisonment. Okay? Next we have intentional torts to property. And here there's three principal forms that we examined in class. Trespass. Remember here, the really critical thing with the trespass elements is to know that we're not trespassing on the tort is not with regard to, the breach isn't with regard to coming onto a property that isn't yours, right? It's encroaching on the exclusive dominion of that property. So it's a legal question and not always a property physical related question. Then we have trespass to chattels, which we know is tied to the idea of conversion, but they're two distinct intentional torts here. Trespass to chattels is some sort of incursion, some sort of activity that gives rise to some sort of damage on property, a property item. A chattel basically means like a property item. It can be a computer, it can be a book, it can be a bag. That's the legal term, really broad term for a range of items that are typically owned or possessed by one party. And then finally we have conversion. Again here, this is the intentional tort whereby the defendant is taking an item without the permission, stripping the exclusive dominion of that property from the rightful owner or the plaintiff. And again here we have the primary defenses, which are consent, which are public necessity. Public necessity, again here we're dealing with a public official who's acting on behalf of the greater good. And then we have private necessity, where it's a private individual typically acting in a more discreet fashion where he or she are looking to safeguard their own interest or an interest of a family member. So that is a quick summary of the intentional tort section. Again, know the distinct elements for each intentional tort to property and to persons, and also the defenses that apply to each. I can stop and then field some minor questions before I transition to the next major section. Any questions with regard to intentional torts? Yes?
What would you say the major differences between conversion and trespass to chattels?
So the primary distinction between conversion and trespass to chattels is, with conversion there's an actual taking of the item. It can be a short amount of time, it could be 5 seconds, and it's clearly going to be tough to bring. You can bring a conversion claim if your computer has been stripped for 5 seconds, but it's going to be tough to demonstrate damages in that respect. With trespass to chattels, it's some sort of interruption, some sort of striking of that item that leads to it being damaged, that leads to it being depreciated. So it's less so a taking of the item, but some sort of activity where the defendant...
So I broke your computer.
Exactly. You walk by, you rush by, you run by this little highway right here, and you intend to hit my computer to break it. You haven't taken it, versus you running out of the classroom with my computer for 10 seconds. And let's say or 10 minutes, you've interrupted my ability to conduct this review session for 10 minutes, which I'm going to articulate at some forum. And I get fired as a consequence of that. Professor Bailey doesn't have a job, I'm going to sue you for economic damages.
If I take your computer out there for 10 seconds, I only kind of keep it for 10 seconds just playing a game, and I destroy it.
Yeah, then I would bring a claim in both trespass to chattels and conversion. Because it's going to be tough to say that the 10-second taking of the item qualifies or gives me access to the kind of damages I want for conversion. In that respect, the trespass to chattels theory is more effective. So a lot of it is strategic. On the exam, you'd argue both, right? But in court, you'd likely, the far more fruitful claim or theory is the trespass to chattels. But on the exam, I want you to argue every argument that you can make a good faith argument for with regard to the elements. Especially if you're arguing on behalf of the plaintiff, right? The plaintiff is going to want every argument possible to come to court and let the court decide whether they're meritorious or not. Brittany?
What type of tort is nuisance considered?
So nuisance is a distinct sort of tort that it can depend. So nuisances can be negligence and they can be intentional torts as well. We didn't spend a lot of time in class on nuisance, so I'm not going to test you on nuisance. It's typically an area that's addressed in advanced torts, but it depends on the same sort of thinking that we have with intentional torts and negligence. So let's say it's a steel mill miles away from your home, and they know that their pollution has a detrimental effect on the neighboring area, it would be intentional nuisance in that regard. But if they don't know and it's a consequence of them falling below the duty of care, then it'll be negligent nuisance.
Thank you.
Yep. Okay, intentional torts pretty straight away. Let's move on to the next area, negligence. Yep.
Do you assume the risk for intentional torts too, because we've only talked about the negligence?
No. So assumption of risk is a defense that ties specifically to negligence. Yep. Yep.
So consent can be a defense to like property.
Yeah. Mhm. So you say, hey, I'm not trespassing. The owner gave me permission to come on to my property and play basketball on Saturday morning. Yeah. Consent applies to intentional torts.
But if you overstayed that welcome, then they can bring a claim.
Exactly. Yeah. Yep.
Trespass the child, the intent to like do the activity of taking your computer or using it, but there was an intent to damage it, like that was accidental, would it still be a trespass to child?
Well, there's with trespass to chattels, again, remember the intent is not tied to taking. That would be a conversion, right? Conversion is the actual taking of the item. With trespass to chattels, it's an intent to cause some sort of damage or harm to the chattel, the item. Yep.
Okay, private citizen is trying to defend the public good.
Mm-hmm.
Like I was thinking, like a superhero or something.
Yeah.
Would it be public necessity or private necessity?
Well, remember here, you need both elements. So, a superhero isn't a public official.
So
Exactly. So it would fall short of being a public
Would it be
necessity.
either?
It might be a private necessity, yeah. So, again here that the private necessity doctrine is a bit broader and more welcoming than the public necessity doctrine. So, in the superhero context, he might not be acting to kind of advance his own private interest. However, he is advancing a broader interest, which might have some sort of private benefit. One might argue, right? Maybe it's enhancing his or her prestige. Maybe it's enhancing his or her reputation as a superhero, and so on. But
Superman has a lot of money to the city.
he does, yes. And Batman, all these guys, Catwoman, all of them owe a lot of money. But the idea here and the reason why public necessity is far more stringent is that it kind of functions as a governmental immunity based doctrine. The objective here is to essentially protect the city, the state, the municipality from having to pay damages to a private plaintiffs. So that's the primary distinction. And remember here with private necessity, even though the defense might stand in the private necessity context, you're still required to pay the plaintiff for the damages you brought forth on his or her property. Not always in the public necessity context. Sometimes, depending on the nature of the facts and the extent of the harm. Yep.
Okay, so I'm just kind of confused with that distinction, because I think we had like the Sirocco case where like the mayor of San Francisco.
Yeah, that was public necessity.
Okay.
Because he was a public official, he's the mayor.
Okay, but then I think on your midterm, you had like the firefighter inside the house, so he wasn't technically on the clock, so.
No, the mayor was acting in his capacity as a mayor on that day. In my hypothetical, again, he was on his day off. It was a Sunday, off hours. He was not in
So
fireman's
we can't
clothing.
hold them to like public necessity, because don't they have like more specialized training than the average layman?
It's really important to read the facts really closely and not just apply the doctrine wholesale. So in that context, no, there was a number of triggering facts in that question that suggest he was at home, he was on his private time, it was his day off. He was protecting the private interests of his home and his neighbor. That isn't a public. He's not acting in a public capacity if the harm he's looking to protect is that micro in nature, right? If it suggests that he rushed to his room and grabbed his equipment and the neighborhood at large was in danger, those facts might suggest perhaps that he's shifting from a private individual to a public official. In the Sirocco case, he was clearly the mayor. It was a work day. He was there on his capacity as a mayor. So the facts are dramatically different than the hypothetical in the midterm exam. So it's really important to use the facts to help you steer how the doctrine is going to be analyzed.
I
I just want to follow up. I got that same, I have the same thing.
A lot of people have that.
Is,
Yep.
where it's like, I think particularly of any profession where you're a mandatory reporter, right? So it doesn't matter if you are in a, let's say for example, I'll just use myself. I am trained to do first response for sexual assault victims.
Mhm.
So I am, because I took an oath to protect them in a vulnerable time, I took an oath that I am a mandatory reporter for the state of Michigan. So if I see someone who's in this position that is dangerous or unsafe, say I'm driving down the street and I watch a man hit a woman and she wrecks the car, right? I'm required to report that even though I'm not working in that position at that time.
Okay, so
I think that's why.
I'm going to raise a really important point for my exam and the bar exam moving forward. You never want to assume, kind of specialized knowledge on the exam, because every jurisdiction conducts these different scenarios distinctly. We know that from our discussion on Good Samaritan statutes, right? So what you're talking about is analogous to a Good Samaritan statute, which compels specific individuals with specialized training to have to act in some context. That isn't the case for other jurisdictions.
Got it. Okay.
Right? So you don't want to assume specialized knowledge on my exam or the bar exam, because different jurisdictions do things differently. In some jurisdictions, you might be right. Firemen might have to act as a consequence of them taking a specific oath as firemen, where that role kind of follows them on the job 24/7 the entire day, right?
Yeah.
But that isn't always the case in every jurisdiction. So what I'm providing you with in tort law is obviously broadly fractured, a lot of division, a lot of conflict across jurisdictions. What I'm providing you with is majority rules, right? So the majority rule is with regard to public necessity is that unless you are on the job, element number one, public official, acting to advance the interests or protect or safeguard the public good at large, element number 4, regardless of your specialized knowledge as to what firemen do, what mayors do in jurisdiction X, that doesn't matter, right? We need both of those elements to distinguish the public necessity from a private necessity.
I think drawing the comparison between the Good Samaritan and that type of situation that now makes sense.
Yeah, yep. Okay? Okay, negligence. We then moved on to negligence. I'm gonna move through the negligence review in a non-chronological way, obviously, because we went back, when we advanced forward, we discussed specialized doctrine that relates to specific elements. I'm gonna move in an elemental kind of fashion versus a chronological fashion. Okay, element number 1, do you have a duty to act or not? Right, we moved forward assuming that most defendants do in fact have a duty or not, but then we assessed, we visited doctrine and we identified the specific rule called the no duty to act rule. We know that there has to be some sort of nexus between the defendant or plaintiff that mandates the defendant to have to act. Some congestion. Otherwise, the no duty to act rule stands. And it's a good segue because we can talk a little bit about Good Samaritan statutes right now. So unless there's some sort of relationship, whether it be familial, right, whether it be a relationship that arises as a consequence of the fact pattern, so if individuals are conspiring in or engaged in a collective enterprise that gives rise to them having a duty together. So let's say you are lost in the forest, right? And Anthony, you're lost in the forest. Hopefully it doesn't happen. But you're moving by yourself for roughly an hour, and then 3 miles from walking through this forest trying to find daylight, you run into Eric. Right? Eric's a stranger. You have no clue who he is. Let's assume that you guys didn't have torts class together. But you and Eric decide, hey, we don't know each other. We have no relationship to one another. But it might be more effective for us to work together to strategize how to get out of this forest, right? No previous relationship, but your collective decision at that point ties you or weds you to one another by essentially agreeing, engaging in an informal contract of sorts, right? And at that context moving forward, let's say, for instance, Eric injures you down the line. Eric looks like a really friendly guy, so it's not going to happen. But you want to bring forward some sort of claim against Eric in negligence moving forward. But Eric says, hey, I don't know this guy. I have no duty toward him. You're going to want to articulate this common enterprise of you collectively attempting to get out of the forest as the relationship that gives rise, that creates that nexus where Eric has a duty towards you moving forward. So contract, whether formal contract or verbal contractual relationships, give rise to a duty with regard to element number 1 that can trump this no duty rule. Yep.
Is that a special relationship or is that different?
It could be a special relationship. You could articulate it as a special relationship. And the special relationship, can be one that's established. So a romantic relationship, a friendship-based relationship, a professional-based relationship. Those can be argued as special relationships. Clearly, we have some that are indisputable. Family being one, right? So family and the various relationships tied to family are clear-cut special relationships. Some special relationships, again, arise from a specific agreement to engage in an enterprise of some sort. But those are the things you're looking for. Some sort of nexus that enables the plaintiff or leads the plaintiff to argue that there is a duty to act on behalf of the defendant. Yep.
Like those 2 boys that the girl got drugged and then they acted.
Exactly.
That then got them under that duty.
Yeah. Mm-hmm. And then we have Good Samaritan statutes. In many jurisdictions, some jurisdictions some jurisdictions rigidly apply the no duty to act rule, which we discussed a couple of weeks ago. Remember, can be not the best policy, especially if we're dealing with individuals who are injured, individuals who are going through some sort of emergency. The no duty to act jurisdictions don't mandate a stranger to have to act on behalf of that injured or emergency-ridden individual, again, because it opens the prospect for liability. However, some jurisdictions have enacted Good Samaritan statutes, and Good Samaritan statutes are essentially, and we have one here in Michigan, which applies to medical personnel, again, which limits the liability of an individual who acts on behalf or acts in a philanthropic fashion to help an individual who is exposed to some sort of emergency or some sort of peril. But what I want you, the majority standard on the exam is the no duty to act rule. Unless I specifically provide you with a Good Samaritan statute, I want you to use the no duty to act rule as the default rule on the exam. Okay? That's element number 1. So the fundamental question you want to ask yourself before you make a negligence claim on the exam is, did the defendant have a duty toward the plaintiff? Right? Obviously, we know that if the prompt is open-ended, plaintiff is always going to argue yes. Defendant, in some respects, if the facts support it, is going to argue no. Okay, moving on, element number 2. Did defendant breach his or her duty of care toward the plaintiff? And again, here to pivot toward more specialized doctrine, recall here, much of the analysis is going to be contingent upon the legal character of the plaintiff in question. Is the plaintiff a trespasser? Is the plaintiff a licensee? Is the plaintiff an invitee? Is the plaintiff a child of tender years where the attractive nuisance doctrine applies? If he or she is an invitee, then obviously we apply the reasonably prudent person standard, RPP. If the person is a trespasser, avoidance of willful and wanton conduct, really low threshold. Same for licensee, avoidance of willful and wanton conduct. Attractive nuisance doctrine, a duty, 3 elements. We're going to use the abridged, shortened version of the second restatement rule. 3 elements. Primarily, did the defendant have knowledge that there were children in that surrounding area? Did he or she take steps to mitigate the prospect of the nuisance being attractive to the children? That's kind of a summary. I've memorized the 3 elements, but a summary of the 3 elements that you want to be mindful of. And in addition, after assessing what the legal character of the plaintiff is, and again, remember here, so some really important things you want to be mindful of on the exam is, like the case involving the Cleveland Indian baseball fan, sometimes the parties are going to argue and have different kind of ideas or contentions as to what their status might be. In that case, the fan who had left the stadium and went on to the Cleveland train system was arguing that he was an invitee. Obviously, he wants invitee status because the threshold that the defendant has to meet is going to be higher. Right? The city was arguing that he was in fact a trespasser once he came onto the rail and was hit by the train. So each party is going to argue a different theory regarding in line with what advances their interest best. And also know that depending on the facts, that a party that is in one instance an invitee can transition into being a trespasser and vice versa, depending on the scope of the invitation or permission or consent. So that status is not entirely permanently affixed on you. It can be revised by the facts in question. So be mindful of those three designations with regard to element number 2. In addition to element number 2, when we're thinking about how to measure the common law duty of care, whether it's the RPP standard or the lower willful and wanton standard, we're looking to additional metrics to assess, to provide us with a strong presumption as to whether defendant had in fact breached or not. We're looking for the private standard of care, again, which is the standard that's assigned by the institution that only governs the institution itself. Now remember here, if you argue private standard of care on the exam, the provisions, the specific things that it's talking about, has to be tied to the breach in question. So if the provision in the private standard of care is talking about cleanliness or the physical appearance of a showroom at a store, but not talking about safety, then the private standard of care is not going to apply if the issue in question is safety. So there's a nexus requirement, a relationship requirement built into the private standard of care. We then moved on and talked about negligence per se. Sometimes the standard of care is assigned by law, by statute, either by federal law, and obviously if it's federal law, it's going to have more weight, state law, city municipal law. Recall here, really important, that violation of statute, negligence per se, is not automatic evidence of violation of the common law duty of care. We talked about some scenarios, some examples, where violation of a statute actually indicates conformity with the common law duty of care. So it's a presumption, a really strong presumption, but not an automatic indicator or evidence of violation of the duty of care. And then finally, third, we have custom. Custom is a standard, a benchmark that is privately established through the collective operation of businesses, corporations, institutions within a specific custom. And it, like negligence per se, again here, is not binding evidence demonstrating violation of the duty of care. Again, here it's only a strong presumption. Okay, and that's element number 2, breach of duty of care. Element number 3, we need a legally cognizable harm. That is a sub-rule for element number 3, legally cognizable harm. It can be trivial, it can be de minimis, it can't be the kind of harm that does not merit or justify proceeding with litigation. And again here, this can be arguable, it can be contingent upon the facts. The defendant here obviously is going to look to suppress the significance of the harm. Plaintiff is going to be creative, industrious, to argue that the harm was in fact not de minimis. Fourth, factual or actual cause. We have our primary test here, but-for causation. We also have 2 additional sub-rules. But-for is our go-to, but again, we know that We're going to rely on these other two in distinct specific scenarios. Substantial factor test applies to scenarios where we have two defendants and we're not sure which defendant gave rise to the harm. We still use but for when we have two or more defendants, but we know which defendant brought forth each individual respective harm. Substantial factor is used again when we have two or more defendants and we're unsure as to which defendant brought forth either the one cogent harm or the several segregated harms. That's when we use substantial factor. Yep.
You want two IRACs for two different tests or one?
No, so it's still one IRAC because again the issue, the primary issue is a negligence issue. So there are two sections to the fourth element, or two sub parts with regard to the analyses to the fourth element. And then third, we have lost chance or last chance doctrine again here, which applies to medical malpractice context, which we examined this past week. Again here, this deals with medical scenarios where the negligence of a physician or some sort of medical professional either could have prevented the harm from taking place or could have mitigated the harm in some respect, alleviated the sort of harm. But by virtue of not acting, by being negligent, he or she did not exercise their last or lost chance. So we want to use lost or lost chance in addition to but-for causation if we have facts that suggest that if the physician would have acted, he or she could have mitigated the prospect of or prevented the harm from ever taking place. Okay, that's element number 4. Finally, 5. Element number 5, we have scope, we have proximate cause. And here the rule is the scope of risk doctrine, 2-part rule, both elements resting on foreseeability. Was the risk foreseeable? Element number 1. Was the plaintiff foreseeable? 2-part analysis, meaning that in your analysis you want to break down proximate cause into 2 distinct components of the analysis. One focusing on the nature of the risk. Is this the kind of foreseeable risk that arises from the fact pattern in question? And finally, are the plaintiffs themselves foreseeable? Okay, here remember we talked about intervening versus superseding causes. Again, intervening cause, and this, again, the assessment with regard to intervening and superseding rests entirely on foreseeability in the analysis within proximate cause. Again, intervening is when we have an additional party, act or actor, that interrupts or intervenes within a specific factual scenario. It remains intervening if the act or actor, the risk, is foreseeable, right? It becomes superseding if the actor and the harm brought forth by the actor is unforeseeable. And remember here, the practical stakes in question are, with superseding, cutting the causal chain, any harm that takes place or is experienced by the plaintiff or plaintiffs after the intervention of the superseding act is pinned on the superseding actor and not the primary defendant. Right? And we talked about how we have a range of actions or actors that will always or generally be superseding. Right? We talked about suicide as the majority standard here, in the vast majority of situations being a superseding act, because of the aberrational, I guess almost deviant nature of suicide. Know the rule here, know the exceptions. 2 exceptions with regard to suicide being a superseding act. First exception, did the defendant know about the circumstances, the symptoms, the affliction of the plaintiff, where he or she might have an inclination towards suicide, previous knowledge? And this is where specialized relationship can be really helpful. Second, did the actions of the defendant give rise to some sort of immediate impulse on the part of the plaintiff to attempt to take his or her own life. Yep.
So like, when we apply the exception for the superseding act of suicide, like for instance, if a wife knows that her husband's suicidal, then at what point is she liable for his death? If he commits suicide, what if he just randomly commits suicide one day? It's not really her fault that he committed suicide. So at what point, what degree, I guess, are you
Well,
considered liable?
well, that's going to be addressed by your but-for causation analysis, right? So if it's too attenuated to the breach of the defendant, so let's say it takes place 3 days later as a consequence of something that the defendant didn't do, then you have a strong but-for claim as the defendant that, hey, this wasn't my action. I knew about this, but my specific action on that day did not give rise to that suicide or that suicide attempt. So remember, all these elements work together, right? They're intricately tied. You need all 5 of these elements to give rise to a negligence claim. So even though it meets the second or the first exception of the suicide majority rule, still need but-for causation. The claim's still going to fail if you have elements 1 through 3 and 5, but don't have 4, right? The plaintiff is not going to win unless he or she has all 5 elements. We also talked about criminal acts being superseding acts as well, and intentional torts also qualifying as superseding acts that break the causal chain. Okay? So suicide, criminal acts, intentional torts, the sorts of activity on the part of new defendants, new actors that give rise or that break the causal chain and qualifying as superseding acts. You could have negligence. Remember here, additional acts of negligence can be superseding acts just as long as that they don't meet the 2 mandates of foreseeability within the scope of risk doctrine. And those are our 5 elements of negligence and all the sub-doctrine we want to be mindful of as we work through our analysis of negligence claims on the exam. Now we can talk about, so one quick point about when we go back to element number 4, but tying specifically to substantial factor here, right? So remember we talked about comparative fault versus comparative negligence. Those aren't the same thing. So when we bring a substantial factor analysis, and if the question asks you to argue comparative faults, here comparative fault is looking to divvy up the liability of each defendant when we have 2 or more defendants to help us assess what damages should be when the court rewards damages. So know the distinct, and really important, on the exam, I don't want you to argue damages unless I specifically ask you to argue damages, right? Damages aren't a element of intentional torts, negligence, strict liability, and so on. Only argue damages if I ask you to do so. Comparative fault isn't a question of damages per se, right? It's a question of legal liability that helps steer how we assign damages, but it's a separate question. You can almost look at it as kind of a precursor question tied to doctrine that helps us assess what damages should be. But comparative fault, again, is assessing legal liability when we have 2 or more defendants. Now let's transition to the defenses that can be made to negligence. Okay, we have defenses. Let's go through the defense. Is it tied to
Just real quick.
comparative fault?
Would you be specific to say pure or modified, or should
Yeah.
you assume pure?
Yeah, no, assume pure. Remember here again, the majority rule is the pure comparative fault standard. Michigan abides by the pure standard. Yep.
I forgot exactly what my question was going to be, but it's the difference between comparative and contributory.
Yeah. So we'll talk about contributory negligence now.
Oh, okay.
Yeah, as one of the defenses. So the defenses to negligence, again, contributory negligence. Right? Contributory negligence is the defendant saying, hey, the plaintiff contributed to his or her harm here, either as a way to extinguish liability entirely on the part of the defendant or to shift some of the liability on to the plaintiff. Okay, and remember here, contributory negligence the way we construct it as a defense on the defendant is to go through the elements of negligence the same way we would bringing a conventional negligence claim. With some tweaks, right? Duty of care, obviously, plaintiff owes a duty of care to himself always. Or herself, always, right? That's what the defendant's going to argue. Breach of duty, plaintiff breached their duty to themselves. Can't be a trespasser onto yourself, so it's going to be RPP assessment. Then we have assumption of risk. Assumption of risk, again, primary distinction between contributory negligence and assumption of risk here is specific, or not specific intent, but intent on the part of the plaintiff to engage, participate, partake in the activity in question that gives rise to harm. We have explicit or express assumption of risk, that implied assumption of risk, explicit again, a better defense for the defendant, again, because it can be a categorical bar from liability. Then we have defenses not on the merits, statute of limitations, preemption. One quick note on statute of limitations. Know that if we're dealing with a minor here, statutes don't begin to toll until the minor reaches the age of majority. So if you are a 15-year-old and you're riding your bike down the street and you're hit by a car, but you decide not to bring the case until the age of 19, but the statute of limitations is 2 years, you're good. Because the statute of limitations doesn't toll until you're 18, you have until the age of 20. Quick note on preemption here. Right, federal law trumps state law trumps local municipal law. We have full-fledged preemption, and we also have partial preemption. You want to read the facts really closely to see if the conflicting laws are only in conflict with relation to specific language in the statute, or a specific prong or section of the statute, or if the entire statute is identical in language or in objective or spirit, where we might have full-fledged preemption.
Give us an example.
Yeah, so let's say, for instance, there's a federal law that restricts possession of advanced, let's say, a rifle, right? Advanced rifle or machine gun, right? But state law, let's say we have a state law, Oklahoma, which is very Second Amendment friendly. It allows individuals to hold or possess machine guns. Federal law is going to trump, and that'll be full-fledged preemption because it deals with a specific area of law. Right now, if the federal law is vague in nature, to say advanced weaponry of some kind, and the Oklahoma state law is dealing specifically with machine guns now, that could be debatable, right? And Oklahoma is going to state maybe a 10th Amendment state sovereignty right to say that, hey, we have this right to hold guns because, or machine guns because the federal law is unclear. And the federal law is going to try to make the claim that advanced weaponry encompasses a machine gun.
Isn't tort law mainly state law though?
It is, but federal law will still trump them. Yeah, it's a question with regard to supremacy clause. So it is state law unless a federal rule or ruling of some kind, whether by the Supreme Court or by statute, preempts state law. Yep.
Is that the same thing as express or implied?
It can be, yeah. Express is when the language itself is explicitly discussing an area of law. Implied is if the language implies it. Again, here the distinction is going to be based on the facts in question. Remember the case we read dealing with the federal aviation law conflicting with the state of Florida aviation law? Federal law was unclear. It was vague and ambiguous. Right? They were making an implied federal preemption claim to say that even though this language is ambiguous, we were talking about the plane colliding when it reached land. It had to be a collision on land, not in the air. Okay, so those are the primary defenses on the merits and beyond the merits. But remember here what you want to do as a defendant before you make the defenses, before you look to the defenses, is to look to torpedo one of the elements. That's the best way to bring down a claim on the part of the plaintiff before you even shift on to the defenses. So if you can say, hey, there's no but-for causation, then who cares about assumption of risk and contributory negligence, right? If you could say you had no duty toward the plaintiff, then we don't care about the defenses. So you always want to lead with arguing against the elements specifically before you shift and move on to the defenses. Okay? Yep.
I'm doing Iraq form and we're going through the elements. If I can establish in that essay that there is no duty, do you have an expectation to go through all the elements?
Yes.
Right?
Yeah. Always, because you want to demonstrate analysis of each component of the IRAC, even though, and again, much of this is going to hinge on which party you're arguing for, right? For the plaintiff, you're obviously going to be persuasive and advocate on behalf of the plaintiff's interests, so you're always going to want to make a good faith claim that there is a duty, there was a breach, and so on. On the defendant's side, you're going to want to argue, hey, the duty of care might be weak. However, you still want to go through the analysis and show why it's weak, and show why it'd be defeated, and argue why there's no duty of care in this specific respect. Yep.
So you think one element is particularly weak, but maybe not the others, you can just argue against that one particular element and decide you don't have to go through all of them?
You do have to go through all of them, always, yes. But if your strongest claim as a defendant is proximate cause, and a lot of this is going to be contingent upon the facts, right? So the facts are going to steer you and lead you as to which kind of claims and arguments the defendants or plaintiff are going to want to make. So always lead with the facts. But I still want you, so let's say the defendant's strongest claim is proximate cause, that the plaintiff was unforeseeable because he or she was sprinting through the backyard when the lawnmower was left on when he went inside the house to drink lemonade and tripped over the lawnmower, right? It's unforeseeable that somebody sprinting through your backyard while the lawnmower is on, they're a trespasser, right? We have the avoidance of willful and wanton standard, which is beneficial to the defendant. You want to hone in on the argument, but you still have to go through the remaining elements. You have to always work through the analysis on my exam and also the bar exam. Yep?
So what's the difference between that and contributory negligence if you have to go through all the elements?
Because contributory negligence is a distinct claim.
Okay.
Contributory negligence is a defense. The defendant arguing against proximate cause is linked to the fifth element of negligence.
I wrote something on my notes, I'm not sure if I was incorrect. I wrote risk doctrine.
Scope of risk doctrine.
That's just scope of risk, okay.
Yeah, proximate cause, two-part rule.
And there was another question, what was it we did with the hypo with the gun? That minor?
Where is the card?
I don't know.
You have it. No, it's gonna take a little bit.
Alright, we'll continue, but we did a hypo, yeah.
Okay. Okay, medical malpractice. We talked about medical malpractice. Remember, two forms of medical malpractice we want to be mindful of. First form is medical negligence, when the physician is actually engaged with the plaintiff or patient in the procession of a surgery, of some sort of operation, where they fall below the standard of care, which is set forth by the industry. Here it's a custom-based standard. Custom-based standard with regard to medical negligence. Second, informed consent is the second type of medical malpractice question. Remember here, really key, emergency qualifies as an exception. In the same way that it qualifies as an exception in the battery context, also functions as an exception in the medical malpractice context with regard to these two areas of doctrine. Then we talked about products liability. Products liability, three forms. Manufacturer's defect. Three elements we're looking for here. Design defect, I want you to use the 4-element second restatement standard, largely based on the hypothetical alternative. doctrine? Is it financially feasible? Is it practically feasible? Is it a tweak that doesn't entirely reform or change the initial design? Again, driven largely by having to call on expert witnesses here. And then finally, information defects, which I'm not going to test because we didn't have a lot of time to discuss in class, but here the majority standard is the adequate warning rule. Yep.
For malpractice, you want us to IRAC that with negligence?
Yeah. And again here, the distinction with medical malpractice, the change is going to be element number 2, breach of duty. Right? Because the standard changes for physicians, obviously. It's based on the industry custom that physicians have to abide by. Yep.
Do we apply the medical standard of care as the test in malpractice questions?
Yes, element number 2.
Okay.
Medical standard of care, remember here, largely driven by expert witnesses as well. So a physician within your specific area of practice and specialization, so it's a specialist within your area of specialization, coming in to testify to argue that your conduct deviated entirely away, if you're the defendant, from prevailing custom. If you're the plaintiff, it either conformed or is still an acceptable form of practice. Yeah, so here with medical malpractice, we're just shifting the standard of care with regard to element number 2. The remainder of the negligence analysis remains the same.
Okay.
Yep.
Product liability is its own plaintiff for plaintiff.
Yes, because remember here, product liability is strict liability, right? So it's not a negligence analysis. Products liability is strict liability. So the elements that are applied to manufacturer's defect or design defect are standalone elements or distinct elements that are being conducted entirely differently, right? So strict liability we know is an entirely different theory that is favorable to the plaintiff. Don't have to prove causation, don't have to prove intent, we're just proving harm. But also know, so one thing to be mindful of, if you're a plaintiff bringing a products-oriented liability claim against a defendant, and let's say the defendant, remember here, isn't a commercial distributor, so if you see a fact pattern involving parties where it feels like a products liability claim, but you conclude that the defendant is not a commercial distributor, you're out of luck because you can't bring a strict liability claim against them. But you're in luck because you can still bring a negligence claim, a conventional negligence claim against them. So a third-hand seller, somebody you might buy let's say you're a musician and you buy a guitar off of Craigslist, right? From Jennifer, who was in a rock band but decides that her last album didn't sell well and she's going to go to law school instead, right? She's not a commercial distributor. She didn't make that guitar. She didn't retail that guitar. But she used that guitar for 2 years before she realized that performing in front of audiences isn't the same as a karaoke bar. Right? You can still, let's say you buy the guitar and you're playing at home and you cut your finger because one of the strings was poorly maintained. We can't sue Fender, who made the guitar, but we can sue Jennifer to argue that she did a poor job maintaining this guitar. You might not want to sue Jennifer because she might not be solvent, right? But if she's solvent, you can still bring the claim because it meets the theories of negligence. But again, the strategy is an entirely different question you guys can address once you become lawyers down the line, whether there's damages or not, right? But we always want to be mindful of solvency for practical considerations. Be less mindful of solvency on the exam because I want you to, the exercise with the exam and the bar exam, really important, right, is to demonstrate to the grader, the examiner, that you're familiar with the elements, that you can conduct the analysis thoroughly. The practical considerations as to whether is this a really good case or not, we don't care about that, right? Because the examiner just wants to know that you can issue spot and analyze effectively. It might be a horrible case to bring to court, but that's not the objective at hand with exams. Yep?
If we get an exam question that's related to government immunity, how would we...
Oh, I forgot to discuss the immunities.
Because I know that FTCA, the U.S. is liable if they act like a private individual, but then in the context of the military, is that basically the fair section? Is that just like a no duty to act, or they have no duty because they're on active duty?
So let's discuss immunity really quick. We'll lead with governmental immunity. Remember, the old rule here was really rigid and really draconian, where if you're a government employee of some kind, you were automatically immune. The new Federal Torts Claims Act changes that, and now we're assessing the government and its agents. When we say the government, we're thinking about agents acting on behalf of the government, right? So vicarious liability, effectively. We have the Federal Torts Claims Act apply, which means that we're viewing the government agent in the same way we would any other individual, applying RPP. Now, the distinction here is that we can bring punitive damages against the government agent. That's the primary distinction. Now, the Ferris Doctrine is a specialized doctrine tying to governmental immunity, again, which has been interpreted broadly. So we only apply the Ferris Doctrine if it's a scenario, a factual scenario dealing with the armed forces, right? The military sections of the government. And here the Ferris Doctrine as it stands now, right? So this is an area where con law and torts for us come together. The one precedent we want to be mindful of on the exam, there's a couple, but one of them is Purcell, is to hold that we interpret the Ferris Doctrine broadly, which construes active duty to be almost anything. As soon after, everything after you've signed that contract to be part of the Navy, the Air Force, the Army, right, qualifies presumptively as active duty as a consequence of Purcell. Right, so it's going to be hard on the exam. So let's say, Veronica, I join the Navy, right? And I sign, and like 2 weeks later, I'm going to the gym to play basketball with my friends. It's the weekend, I have some time to visit my family, and on the drive back home, I get in a car accident. Ferris Doctrine seems to provide good case law for the military that I'm still in active duty. Right? And I might argue, hey, the military here was negligent by allowing me to go on this trip. That's a negligence theory. Maybe not the strongest theory, but they can probably defeat that with the broad construction of the Ferris Doctrine.
So let's say that's the fact pattern we get in the exam for one of the essays.
You're not going to get that fact pattern.
Okay. Well, if we did, the thought process would be, well, the facts state they're in the armed forces, so I'm just going to state the Ferris Doctrine and that we cannot bring a negligence suit against the government.
You can bring a negligence suit, right? Because Purcell brought a negligence suit in suicide against the military, but it's likely going to fail.
Okay.
You can bring it, right?
It's probably not.
It's probably going to fail as a consequence of Purcell. Okay, so know that, and students have done this before, have cited the Ferris Doctrine to anything involving governmental immunity. No, right? Only applies to the military. Very specialized doctrine tied to the military. We talked about family immunity. Again, and here the rule was that you couldn't sue spouses, couldn't sue family members. That shifted. Right? We're holding family members now majority standard to the RPP assessment. Okay? Now again, this is an area I really don't like to teach in First Amendment torts, to be honest with you, because practically speaking, it doesn't make a lot of sense, because in most situations, we know that family members won't sue other family members, right? Because they're effectively suing themselves, whether it be a spouse. Typically, spouses share resources. Typically, especially when it's children don't want to sue their parents, right? Because it's effectively going to have a detrimental impact on them. But know the doctrine and make the claims on the exam as you would, even though you don't think that practically they make a lot of sense. I want to see you work through the elements in the theory. Yep.
So immunity as a defense, is that mostly in element 1 and 2 then, if you were IRACing it?
Governmental immunity? I would like to see you make governmental immunity as a separate claim, as almost kind of a functional defense of sorts.
Okay, so not like...
Yeah, don't work. It gets kind of awkward and kind of sloppy if you built it into element number 1. Because you still have a duty, right? But the immunity effectively accepts that duty from the specific situation.
So you said that would be a defense?
Yeah, I mean,
I could work it as a defense.
Yeah, you want to construct it and frame it as a defense on the exam.
Is that with all immunities?
Yeah, government, family.
Hypothetical,
Yeah,
that stuff.
exactly. Oh, one quick thing about, so I forgot element number 2, common carriers, right? Common carriers are held to a higher standard than reasonableness. Firefighters' rule also held to a distinct standard, a higher standard. You know that firefighters aren't only firefighters, a wide range of other individuals who qualify as public officials. EMTs, guards, lifeguards. Yep, Donovan?
There are the firefighters and the rescue, can all both go to negligence and to intentional torts?
Firefighters' rule only applies to element number 2 of negligence.
Okay.
The rescue doctrine, right, is entirely distinct doctrine where a third party acts. Right? And rescue doctrine is tied to element number 1. But it's also a separate negligence claim being brought forth by the rescuer if he or she is injured. They don't have a duty to act, right? The rescuers have, unless it's a Good Samaritan statute, the no duty to act rule does not bind them to have to act. But if they decide to act and are injured as a consequence of the negligence of the primary defendant, they can bring an additional negligence claim against the defendant, or if it's an intentional tort, bring an intentional tort against the defendant. So let's say you guys are scuffling, right, in a park somewhere, but you're in fact pro wrestlers, but you're only practicing, right? However, you're walking across and you're thinking they're actually engaged in a fight and they're not practicing wrestling, right? You jump in. I know it's I have weird fact patterns today. And Ibby's like, what's going on? And punches you in the face. Right? You can bring a battery claim against Ibby. Because by virtue of you thinking, and remember here, the rescue doctrine is really important because the critical juncture is not making an accurate assessment that they're in fact engaged in a real hostile fight where one of them is in danger. It's a reasonable assessment. So just as long as you can prove as the rescuer to the court that your assessment that they were actually engaged in a fight was reasonable, and even though you were wrong, same as the shoplifter's defense, right? With regard to false imprisonment, shopkeeper's defense, shopkeeper's privilege, right? Only has to be a reasonable assessment on your part. Yep.
Can you do an example of 2 defendants with the 2 different tests, the before and the substantial factor?
Construct a hypothetical?
Yeah.
Okay, I'll try my best. So basically, substantial factor. Let's think about a fact.
What's the difference between
The fundamental difference. So but-for is, you can have but-for tests, and but-for tests will work in scenarios where we have 2 or more defendants. So the principal example is this. So let's say Veronica is walking down the street, right? Anthony and I are, me and Anthony are walking 20 feet behind her, and both Anthony decide, hey man, let's go for a race. You know, I got to lose some weight, and I'm capitalizing on any opportunity to burn some calories. Anthony and I decide to sprint. We don't see Veronica, but we both bump into Veronica. And as a consequence of bumping into Veronica, no, we don't. Veronica. Why morph it today, Veronica? Mexico's in the World Cup. You should be celebrating.
What?
You should be celebrating. Mexico's in the World Cup.
I know, but not in the group that we're in.
Oh, it's a tough group. Yeah. My country's in a good group, so we have a chance to advance. But back to the fact pattern. So Veronica isn't dead, but she bumps her head on the car, has a bad bruise, and good news for Veronica, she can take the torts exam a week later. So we'll remix where it's actually a good hypothetical for you. But Veronica doesn't know whether it was Anthony or me that brought forth this bump on her head, right? Because we both effectively struck her at the same time. So but-for causation is not going to work because she doesn't know whether the but-for cause of this bump on her head was Anthony or me. So therefore, she brings a substantial factor claim to say that shifting liability onto the court and onto me and Anthony in court to argue why it was in fact Anthony that was the cause of this harm. Anthony's going to say, no, it was in fact Professor Baydoun. He's a little bigger than me. It was likely him who caused the bump on Veronica's head, right? And as a consequence of this interplay, the court will decide, maybe Anthony brings an expert witness, I bring an expert witness, and the court decides that liability is 40% Anthony, 60% mine. That's how substantial factor is relevant. But let's say in the same scenario that I push Anthony into Veronica, and that's what causes Veronica to cause the injury. We don't need substantial factor in that situation, right? Because we know that Anthony is the one who struck Veronica. Now, we have two possible claims to bring there, right? Veronica can bring a negligence claim against Anthony and against me, and then Anthony can bring a battery claim against me. So that little tweak in the factual scenario opens up an entirely new window for additional claims that can be brought. But do you get the distinction between substantial factor and but-for?
So if we get a hypothetical that involves more than two defendants and you tell us to assess the damages, are we going to get marked down if we assess it in a way that you don't think is correct? For example, like if we say, oh, defendant A is 60% liable, defendant B is 40% liable.
No, because in most situations there is no incorrect answer. Now, if it's egregiously incorrect, right? If it's clear to see that in the first scenario, it seems that both Anthony and I should have some sort of liability based on the lack of clarity as to who caused your injury, right? Now, if you give an assessment that, hey, it should be Professor Bedu 90% and Anthony 10%, that doesn't feel right? So you might be docked in that regard. But if you say 60-40 based on the facts, 50-50 based on the facts, then that seems a lot more palatable. Okay, I've gone through the material, so now we can just open up to any questions you guys have. Eric?
What's the difference between contributory negligence and comparative negligence?
Yeah, so comparative negligence and contributory, it's just essentially like linguistic distinctions. You have some jurisdictions that have pure contributory negligence standards where you could have contributory negligence beyond 50% that won't bar the defendant from claiming for having some sort of liability. Comparative fault is typically used in jurisdictions where there might be bars, right, based on it being a pure modified standard. But again, here the language is one and the same. I mean, it's just a question of semantics. Contributory negligence is specifically, this way you can I want you to distinguish it for sake of rebuffing confusion. Contributory negligence is only negligence tied to the actions of the plaintiff, contributing to his or her negligence. Comparative negligence is the analysis or assessment done between the plaintiff and the defendant. Does that make sense?
Yeah.
So when you see contributory negligence, just as an offense the defendant can bring, comparative negligence is assessing the negligence of the defendant in relation to the plaintiff.
Means that pure is the majority standard.
Yep, pure is the majority standard that I want you to use on the exam.
Will there be a focus on the forcible rights violation?
No, I won't touch that. One thing to be mindful of is just because you bring a specific theory doesn't negate the possibility of an additional theory. What I mean by that is in relation to tort claims, but also defenses. So if you bring an assumption of risk claim, that does not mean that you might not have a contributory negligence claim to make as well. If you bring a battery claim, that does not mean that you cannot make an assault claim, or a false imprisonment claim, or a negligence claim. Right? So know that by virtue of bringing one claim for the plaintiff, that does not exclude or cross off the possibility of bringing additional claims.
For the minors in immunity, it's still, for exam purposes, age of 6.
Age of 6, or less. And remember here, so one area where a child will become motorized vehicle is a scenario where a child will move from the RPC to the RPP. But know that, so one point, right? So there's some dissonance with regard to the child standard with regard to element number 2 of negligence and attractive nuisance. So the attractive nuisance age is 10 years, 10 or less. Be mindful of that. And on the intentional tort side, a child cannot engage or commit an intentional tort unless he or she is 6 or older.
And that's the same age for the motorized vehicle?
Yeah.
PCs?
Mhm. Yep.
Okay, so you could potentially bring a negligence claim and a battery claim, then you want us to like IRAC separately?
You always separate you always have a separate IRAC for a distinct tort claim or a tort defense. Because whenever you have a claim that has its distinct or separate elements, distinct or separate elements, that has its own IRAC.
Going back to the line of question, if there is anything essay related, should we argue the parent, vicarious liability for the parent?
Yeah, of course. Yeah. So for instance, especially if you have a child who is lesser than the age of 6, then the child cannot engage in an intentional tort. In that situation, if the parent is there or not there, you could potentially bring a claim that the parent was negligent in his or her supervision, then that's a claim you'd want to bring. Eric?
So it's the same for contributory negligence too, that children are capable of, so that's
Yeah.
That's 6 and under. So
Yeah, so it would apply to negligence in all forms.
Okay, so that's like 6 years and 364 days and under, or is it?
No, so once you reach the age of 6 and beyond, then you can engage in negligence. Donna?
Age 10 is for intentional,
Attractive nuisance.
attractive nuisance.
Yeah.
Back to medical malpractice, the second form, which is informed consent. So the analysis would then be that their duty of care fell when they didn't properly inform the patient.
Of information that reasonably should be extended
Right.
to the patient, whether it be information about the actual surgery, operation, or treatment, or whether it be the risks associated with the operation or treatment. Anything that should be reasonably extended to the patient is not given. So it's what distinguishes informed consent from medical negligence is that one is related to the data, the information that is extended by the medical professional, or the lack of data, right?
Right.
And one, the initial form, the negligence, is linked to the actual physical engagement itself. The operation, the surgery, the treatment was done in a way that fell below the duty of care in that specific area.
So if the harm arose out of something in the operation that the plaintiff didn't know about, that would then give rise to the informed consent?
Possibly both.
Okay.
Yeah, then you can bring both claims,
Okay.
for instance.
So best to apply both as the facts and support
Mhm.
both for.
Yeah.
If we're going through the elements of negligence and under breach, you have the reciprocity where it comes up, so we argue that separately or does it intertwine to?
Well, res ipsa is going to be, res ipsa is always going to be a claim only raised by the plaintiff, right? The defendant's not going to raise res ipsa because it doesn't do him or her any good. We only raise this, obviously, if there are no additional facts, no additional bodies of evidence that suggest or strengthen the plaintiff's claim that he or she was injured as a consequence of the defendant's breach. Here we tie in res ipsa in element number 3, legally cognizable harm, right? This is the area where we want to talk about the harm, but also talk about how res ipsa might apply. Eric?
Sorry, another question. It's for the children. So if, like a 5-year-old is driving a car or something, for whatever reason, or a moped, they're still, because they have a motor vehicle, it's raised to RPD, given another 5, and
Yeah.
they are liable.
Yeah, apply the motorized vehicle. It's interesting. I mean, I would like to see how that would work out in court because you can see claims being brought on both sides. But on our exam, I want you to apply the motorized vehicle exception. So if the child is 1 to 5, they're still operating a motorized vehicle.
Okay, thanks.
Quick tips with regard, final tips, and I'll echo this. Again, read the model answer closely, but I'll voice what you guys should be mindful of. Please be clear with your headings. It's really important. Please be very concise with your issue statements. Issue statements should not be longer, shouldn't even be a sentence, to be frank with you. They should definitely not be longer than a sentence. Brief in nature. Bob versus Alex in battery. Jennifer versus Allison in negligence. I don't want to see Bob has a legitimate claim in negligence against Alex because X, Y, and Z. We don't care about that, right? Issue statement, really brief in nature. Use markings, use headings, whether it's issue underline, citing what the issue is, whether it's I, circle, hyphen, tell me what the issue is, rule, R circle, rule underline. In the rule section again here on the exam, no analysis. Just tell me what the rule you're applying is. Here we're just applying the elements, regurgitating the elements. Right? Analysis, be really clean with the analysis. Really important here. Right? Especially when we're dealing with analyses in complex areas like negligence. 5 parts. Right? You can break it down and feature it this way. Element number 1, did defendant O breach a duty of care at all? Element number 2, use numbers, use hyphens, use hashes. Make it as clean as possible. Again, and I tell you this for my exam, but moving forward for the bar examiners, really important. Organization cannot be overstated as to how important it is, and to be clean. I don't want to see endless prose where it's really difficult for me to assess which section of this prose, of this paragraph, applies to what. You got to be clean. You got to be neat the way you mark the sections of your exam, the way you separate the distinct issues you're bringing. Really important. Yep.
Are you okay with us? So if we have like one of the fact patterns, one of the papers, and we're say it's like 3 different negligence claims. Are we okay with maybe like the one negligence claim and then the second one if it's like instead of the rule section saying same rule?
Yeah.
Above?
Yeah. I just want to see on the exam that you've effectively shown me that you know what the rules of negligence are. So if you've done so in a primary negligence claim, I won't expect you to recite the 5 elements again, but it has to be done somewhere in the exam correctly at least once. And again, the hardest part of the exam is going to be the time, 3 hours, right? So, 3. Not decided, 3 hours. So organization is going to be really important.
Do you have an estimate of time for the multiple choice per question?
I give you suggested time for each component of the exam.
Okay.
Yeah. I suggest a specific time that you should allocate to each part.
Okay.
Yeah.
You can use exam 4, right?
Use exam 4. You can write the exam if you choose, if you're better with writing the exam. Again, here, really important, don't bring any commercial outlines. I'm not proctoring the test, so I don't want you to get in trouble by the proctor. Use your outline. Really struggle with your outline this week to memorize as much of it as possible and to make it as wieldy as possible, right? Really long outlines are really tough to use on test day.
Notes. Yes, no. My note here says anything that's self-authored.
Yeah, you can use notes, but again, notes won't be helpful on test day, right? So you want to think you want to think strategically. It's going to be tough to sift through stacks of notes on test day, right? You want to be in a situation on the exam, to be frank with you, since time is of the element, where you're not always referring to your outline, right? Your outline is effectively just kind of there for you, just in case you need to look at it. On bar exam day, it's not gonna be open book, right? So you wanna use this to simulate what that test is gonna feel like. Clearly a torts, a 1L torts exam, the torts exam in my class is gonna be harder than the torts exam in the bar, right? Which is why I allow you to use the outline. But really struggle with your outline, make it really concise in a way that makes it really practical on test day. Yep.
What's the structure of it?
I'm not going to say specific structure, but 1/3 multiple choice, 2/3 fact patterns.
Oh, and when you say fact patterns, it's just essays, no short answers?
No short answers, yeah. Eric?
I didn't see the model answer for the second paper.
Oh, I posted it.
Was it posted?
I think so, but I'll double check.
Okay.
Yeah.
Okay,
The only first one's up? Okay. Yeah, I'll post the second one today. But the second one's not going to be, I didn't organize it in the same pristine way as the first one. Because the first one provides you with the structure, right? So the objective with the first model answer is making sure that I provided you with a clear example of the structure that I like. The second, I'll list the issues that you should have spotted.
Okay.
Yep.
And I know that for us to prove conduct, it's the preponderance of the evidence. You want us to put that in our structure of like, oh, this is how plaintiff will prove conduct, or just
No.
leave that out?
Yeah, I don't care about that. I just want you to work through the elements.
Okay.
I don't care about the preponderance standard unless I specifically ask for it.
Right, okay.
And one thing that students do that I don't want you to do, right? Don't restate the facts. I know what the facts are. The facts are provided on the actual exam. Don't have a fact section of your IRAC. Number one, it's a waste of time. Second, don't provide unless it's helpful to you. But again, outlining is really key. Road mapping, on test day. Don't provide me with a subheading before you IRAC saying plaintiff will bring claims X, Y, and Z, like a summary of what you're getting ready to do. Students do that oftentimes. I'm not sure why. It's not helpful. Again, I just want to see individual IRACs for each claims being brought by each party.
But you want us to match the one fact to the element, right?
What do you mean?
Like,
Oh, you're using the facts to analyze, of course, but you're not giving a
don't completely leave them out.
You're not giving a summation of the facts in the IRAC. The facts are only relevant in the IRAC in the analysis section.
Right.
Mm-hmm.
So sometimes on your slides, like for battery assault, you give us like a layman's definition, and then you get into the elements. Is that supposed to be incorporated into the rule, or you want us to like?
No. No, so the lay definition is just to provide you with a general idea of what the tort is. The rule is just the elements. Nothing else. And one quick thing is a lot of students kind of feel like the more I write, the better my grade will be. That isn't the case. Right? It's not a question of quantity. Right? It's a question of knowing which facts are determinative to the analysis that you're conducting. And sometimes shorter writing is actually preferable because it enables you to be swift, right? Move from issue to issue. The hardest part of the exam, again, remember, is you're likely not going to identify every issue. And if you do identify every issue, you're not going to have the time to analyze each effectively. The A grades are going to be somewhere in the realm of like 80 to 85% of spotting all the issues and effectively analyzing the issues. And be smart. So if you're a poor multiple choice test taker, for instance, and you find yourself having only gone through 13 of them with an hour and 50 minutes to go, know at that juncture that maybe I'll just guess on the remaining multiple choice questions because it's only 1/3 of the exam and I want to maximize my time on the essays where 70% of the points are. Right? So make those strategic decisions on test day, which might be difficult where you're not dedicating a considerable amount of time to the section on the exam where the points aren't as weighty. Okay? Any more final questions? Yep.
Do we really need to understand the difference between wrongful death and survivor claims?
Yeah.
We talked about it in the course a little bit.
Yeah, we did. But we spent some time, I think, one class focusing on wrongful death. And So know the distinction, and here, these are negligence claims, right? So it's not gonna change your analysis. With wrongful death, it's the estate. With the successor's claims, it's a family member, right? You don't know there's a distinction generally, but here we're talking about a party bringing a negligence claim against the defendant for the death of a party. Yep.
Do you have any recommendations of where we could like just practice multiple choice questions regarding torts?
Yeah, I like the Barbary questions a lot.
Okay.
So Barbary are most modeled after the bar exam questions, and I model my questions after the bar exam questions. Some of my questions are actually old bar exam questions.
Yeah, make sure you don't grade us like you're grading the bar. How many grade the bar?
You actually want that. I'm telling you, the bar exam is testing general knowledge of the subject matter. The hard thing about the bar exam is you got to know everything, right? The hard thing about a torts exam is that it's more thorough, nuanced testing. So you want me to test your torts exam the same way I would test the torts section of the bar exam, huh?
Do it like that then.
Yeah, depends. See how the lines do.
God, all gonna fail.
All right, guys, best of luck. And again, if you have any final questions during the course of the week, or if you want to meet in person, email me. And you guys will be fine, hopefully. Just, again, work on your outlines, look at the model answer. Most important thing.
Will you be at your office at all?
Yeah. But let me know what time you'd like to come, so I'm definitely there.
Anybody want me to send this recording to them?